everyone. So I hope that your studies are going amazingly well. So in this video, what am I going to discuss with you? Before I actually go into the topic, let's just talk about the situation. You wanted a 500 rupees, right? You go to your dad and you tell your dad, Dad, would you please give me 500 rupees? He says, yes, it is there in my pocket, go and take it. You go to your dad's, like wherever his shirt is, generally behind the doors we have this habit of hanging the shirt. So it was there, and you go and you take out, and you see there is not one but three 500. And obviously, like every child, you are like, oh my god, I think not the three, you don't want to take all the three, that would be a little too much. But you have the desire to take not one but two 500 rupees. You're like, what should I do? Should I take one, two, one, two? Finally, your heart won over your head and you took two 500 instead of one. So, your dad gave you authority to take how much? One 500, but you took how many? Two 500. Was this correct? Did you have the authority to take this 500? Now, later, when your dad was unable to find his 500, he looked at you and you just gave away by your looks. Yes, I have taken the 500, not by words but by your looks. Now, what will happen? Dad will give you left, right, and flying chuckles. Why? Because you had the authority to do this, but you had no authority to do this. Right? When you do something for which you have an authority, it is intra-vires, that is within the powers, and it is valid. But when you do something for which you have no authority, it is ultra-vires. Ultra means beyond, and vires obviously means powers. Beyond the powers, and it is void. Right? And it is what? And it is void. Now what happens is, when we talk about a company, we know company has this document called the MOA. Right? Company has this document called the MOA, the Memorandum of Association. And this Memorandum of Association has 6 clauses. What are the 6 clauses? Name clause, registered office clause, object clause, capital clause, liability clause, and subscription clause. Right? Now, object clause gives us whatever the company has an authority to do. And when the object clause tells us that the company has an authority to do these acts, it means the company has no authority to do any act other than this 10 or whatever is the number of specified acts. Now, whenever the company does any act which falls within the object clause, okay? If the company does anything which falls within the object clause, it is what? It is intra-vires. And when it is intra-vires, it is what? It is valid. On the other hand, if the company does anything against the object clause, right? If the company does anything against the object clause, such an act is what? Ultra-vires. That is beyond the powers of the company. Right? Beyond the powers. And obviously when something is beyond the powers, it is what? It is. Now when we say ultra-vires can be ultra-vires the act, ultra-vires can be ultra-vires the MOA, and ultra-vires can be ultra-vires the AOA. When I say ultra-vires the act, okay, when I say ultra-vires the act, it is what? Void plus illegal. See, you're going against the act. If you do anything which is against the act, obviously it's not just void, it is also illegal. If it is ultra-vires the MOA, it is void ab initio. About this we will talk in a little while. The whole concept of ultra vires was actually laid down in the case of Ashbury Railway Company versus Ritchie. Right? The whole concept of ultra wires was laid down in the case of Ashbury Railway Company versus Ritchie. So what exactly happened in this case? Now this company had an object clause obviously and a lot of objects were given. I am not writing all the objects, I am just taking those objects which are relevant to our case study. So apart from all the objects, the company had these two objects: to sell, lease or otherwise give on hire railway wagons or railway carriages. That is, I will either sell it, I will give it on lease, or I will hire it. Hiring means basically you are a tenant, leasing means temporary ownership of the property. Then to carry the work of mechanical engineers and general contractors. Now, what this company did was, this company entered into a contract for financing, that is for giving a loan to Ritchie. Ritchie wanted to lay down railway tracks, and for that the company decided to give a loan to Ritchie. Now, then later the company realized that they were not allowed to give the loan. Right? Later the company realized that they are not allowed to give the loan. So the company goes to Ritchie and says, we are very sorry. We don't know. We are not allowed to give you the loan. We were not, we had not read the memorandum properly. But now we realize we are not allowed to give you the loan. So we are very sorry, but we cannot give you the loan. Ritchie is like, no. See, general contractors, you can give the loan. Company is like, no, we cannot give you the loan. We are sorry. We have to cancel the contract. Ritchie is like, I'm going to sue you. They were like, fine, we cannot give you the loan. You can do whatever you want. So when the case went to the court applied the rule of ejusdem generis. What does the rule of ejusdem generis say? When specific words are followed by general words, okay? Like if I say cat, dog, cow, goat and other animals, okay? Now, this is specific words and they belong to a particular species. But this is a what? General word. This four, they are particular animals and they belong to a particular species. Can I say they belong to the species of farm animals? Yes. Yes. But this is a general term, other animals. Now, can other animals include horse, sheep, pig? Yes. Can they include lion, tiger? No, because here I am specifically talking about farm animals. So when we say other derives its color from this species and they will include only those animals which are farm animals. Similarly, applying the rule of ejusdem generis, the court said that when we say mechanical engineering and general contractor here means anything to do with mechanical engineering. Right? General contractors here means that anything to do with mechanical engineering. And giving loan is not considered as mechanical engineering, anything to do with mechanical engineering. So, the court also held that this act is ultra vires. So, when my memorandum specifies some objects, I as a company have an authority to only do those acts. And if I do any act which is against this MOA, it is not valid. So, the first consequence, what? Any act which is ultra vires is void ab initio. Right? Any act which is ultra vires is void ab initio. And the parties in an ultra vires contract cannot sue each other. That means Richie cannot sue the company, company cannot sue Richie. It's void. When it is void ab initio, it's not enforceable by law. That means both the parties cannot sue each other. Now, Ashbury made a contract to give loan to Richie, and then they realized we cannot do. So they called all the shareholders. Now the MD, he was a very a quick and a very what do you say? He was a person who could speak very well. He was a very good orator. So he kind of convinced all the shareholders that we should make this contract. It's an amazing contract. It is a boom to the company. Company will benefit like crazy. Blah 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 blah. He told so much that all the shareholders were like, okay, let's do it. All the shareholders were like, let's do it, let's do it, let's move forward with this. They all agreed, right? They all agreed. Will this contract become valid? No. Even the whole body, that means even if everyone gives the consent, even if the consent is of the unanimous shareholders consent is given, even the whole body, if they agree, the act cannot be ratified. So even the whole body of shareholders cannot ratify it. Right? Even the whole body of the shareholders cannot ratify. That means, ma'am, we can never do. No. See, first alter, then you contract, it's valid. But what you are doing here, you are first made a contract and then you are trying to alter. This is not valid. It's void ab initio. You cannot alter it later. You can alter your MOA and then make the contract, that will be valid. But you cannot first make the contract and then alter it. No. So even the whole body of shareholders cannot ratify it. Now what happens if the act is intra-vires, within the powers of company? Right? If the act is intra-vires the company, but ultra-vires the share, I'm so sorry. Ultra-vires the director. Okay, what happens in this case? So what happens if the act is intra? That means the company can do, but the directors don't have the authority to do it. But the company has the authority, so it is not ultra-vires the MOA, right? It is not ultra-vires the MOA. Company can do, but it is ultra-vires the directors. Then what will happen? The share then shareholders can what? Shareholders can ratify it, right? Then what will happen? Then the shareholders can ratify it. So if it is the company is allowed to do, but the directors don't have the authority to do it. That means, let's say for example, to do it, the directors must get the consent of the shareholders. So the shareholders, in that case, it is the company can do, but the directors don't have the authority. Then shareholders can ratify it. What happens if an act is ultra vires the AOA? Now, if it is ultra vires the AOA, it can be ratified by the shareholders. So, ultra vires the MOA is void ab initio, but ultra vires the AOA is void, but can be ratified. What was happening? What was happening in case of MOA? You cannot alter, you cannot contract and then alter. You can alter and then contract. But in case of AOA, you can make a contract and then also you can alter and it will be valid. And this contract will be valid. So in case of ultra vires the AOA, it can be ratified by the shareholders by passing a special resolution. If you remember, I had told you what is special resolution? 75% votes in favor, right? 75% votes in favor. I hope this is clear. So what happens if any act is ultra vires, it's void ab initio, the parties cannot sue each other. If it is ultra vires, the directors, but intra vires, the company shareholders can ratify it. And if it is ultra vires, the AOA, it can be ratified. But there is a question, ma'am. I have a question, ma'am. How will Richie know Ma'am, how will Richie know that the company can or cannot take a loan? Should he, in the middle of the night, go to the company's office, bang the window, take a torch, I don't know, chill. He doesn't have to do all this because first, if you remember, in the case of incorporation, the MOA and AOA and other documents rather, everything has to be filed with the registrar, right? Is filed with whom? With the registrar. Whenever you file a document with the registrar, okay, under section 399, it is deemed that every person dealing with the company has knowledge about it. What does this mean? See, I, when the document is a public document, I can go to the registrar's office and check the document, right? When the document is a, what do you say, public document, I can go to the registrar's office and check it. Whenever any person comes to contract with the company assumes that person knows. Right? Company will not ask, "Arey, oh Richie, did you read our MOA or not? If not, please go and read and then come back." No, company will assume that he has read the MOA. Company will not ask Richie, "Hey, did you man, hey man, did you read it?" No. Company will assume that Richie has read the MOA. It will be deemed that every person dealing with the company knows about it. And this is known as the doctrine of constructive notice. What is doctrine of constructive notice? I say this Sunday I'm going to conduct a mock test for everyone and then we will have a live discussion about it. It's a real notice. I've told you. I tell you, I'm going to post a story on Instagram on Saturday. The link for the same is given below. I'm going to post a story on Instagram on this Saturday and you please check the story. I'll give you a time when the mock test will be held and the time for the live discussion of the question will be. So when I have said this to you and when I put the story on Saturday, I will assume that all of you have read the story. This is not a notice that I have told you, but this is a constructive notice. I will assume that you have read it. Whenever a person is dealing with the company, it is assumed that he has read the documents before dealing with the company. The company will not ask him. The company will not say, "See, we cannot give loan." No. The company will assume that since he is coming to deal with the company, he has actually read it. This is known as doctrine of constructive notice. I hope these two doctrines are very clear, important also, especially for the foundation students from the exam point of view. I hope it's clear to all of you. Thank you. Happy learning and stay with you.